The Supreme Court's decision on the Act 13 legislation invalidated certain provisions of Act 13 that were intended to impose limits on what local governments could do and impose more uniformity at the local level. With the Supreme Court's ruling, those limitations on local government have been lifted to some extent, and therefore we would expect there's going to be more local ordinance and regulation activity of the industry at the local government level. Rather than having one set of more uniform rules that they can rely upon, they're going to need to address regulation on a more municipality by municipality basis. It's going to require much more monitoring and analysis of what the local ordinances provide and how they may change. It's going to require more internal devotion of resources to government relations at a local level. We're working with clients to basically reinitiate their understanding of how local government works, in essence a zoning or land use 101, so that they can understand how the landscape has changed as a result of the Act 13 ruling, remind them how and under what structure local government can regulate the industry so that they understand moving forward what issues they need to address, what questions they need to ask, and what risks they need to analyze as far as their desires to develop in a particular community. Our clients are going to have to focus more, again, on what is happening in particular communities that either they have assets that they are currently developing or that they may contemplate acquiring in the future. There's going to be a need for much more due diligence and analysis of the local scene. Local government regulation and uncertainty is another risk factor that any of our clients will have to take into account in determining their future business plans. Developers need to approach this in a number of ways. First, you need to be much more attentive to existing regulations in those particular communities and understand how the local zoning rules work. Secondly, operators need to be much more attentive to proposed changes in those regulations in reaction to the Act 13 decision that might potentially make operating in a particular community more difficult, if not impossible. And thirdly, as part of all of that, there's going to be a need to engage more at the local level. Again, since you don't have a uniform set of rules, it behooves operators to make sure that they're in constant communication with local government officials to hopefully have a positive dialogue, but also understand and not be blindsided by potential changes in local regulations down the line. What the Act 13 legislation and Act 13 decision has driven home is that there's an intersection of regulation of the oil and gas industry at the state level and at the local level, and that what BAPS-Callan is able to do is that we understand both halves of that equation. In addressing these issues with our operator clients, we deal with a variety of personnel ranging from in-house legal counsel to environmental and local permitting personnel to landmen and government relation officials. The nature of local government regulation is a blend of regulatory authority, quasi-judicial proceedings, and government relations all rolled up into one. So we tend to find that our interface with our operator clients goes across multiple departments. Act 13 made more of a bright line as to what you could do and not do. With the court's ruling, that bright line is now gone, but it drives home the importance of understanding how local government land use authority overlaps and intersects with state environmental regulations.